First, Mr. Chairman, with the late amendment on the ethics and ethical and philosophical removal, I did a little research in the back on the Google on ethics and morality, and frankly, it changes nothing as far as we are concerned in the bill. Before I start, Mr. Chairman, this bill does a couple of things, but it doesn't do a couple of things, and they're fairly important things. It doesn't give reasonable accommodations to employers, and not once in this bill do we talk about the patient. And I suspect the patient is a fairly important piece of the puzzle in healthcare. First and most importantly, I'd like to note that conscience protections already exist in current statute, as mentioned numerous times by the previous proponents of the bill, both in state and federal law. Title VII, as mentioned, of the Civil Rights Act of 1964 has existed in federal statute for over 50 years. It's been tested and resolved through extensive case law and works in the real world. Healthcare providers are already required to have accommodation policies for practitioners with conscientious objections and to make reasonable accommodations for providers with conscientious objections. The South Dakota Civil Rights Laws, SDCL 20-13 and Administrative Rule 23-10-1 also protect an employee's religious beliefs and conscience. These laws work well in South Dakota today. The definition section of conscientious in this bill is overly broad, including, not anymore, ethical and philosophical, although I think it still remains in a couple parts of the bill, moral or religious beliefs or principles. The bill also applies broadly to, and this is important, any healthcare service, from scheduling to examination, diagnosis to treatment, housekeeping to food service. The biggest issue with these two broad definitions is that this bill will protect good conscience, and this is extremely important, as well as an evil or poorly formed conscience. It gives them the same protections. Let's talk about a few scenarios that this bill will protect. A housekeeping employee who holds sincere ethical beliefs that synthetic cleaning agents hurt the environment and will only use products like vinegar and water to clean rooms. A nurse aide who believes in pacifism and refuses to assist in de-escalating a patient in a mental health crisis. This creates an unsafe situation for the distressed patient as well as other patients and staff. The dietary aide in the nursing facility who believes the use of any animal-based products is cruel and immoral and refuses to prepare or serve meals containing animal-based products to residents. A patient who has a drug overdose and suffered multiple broken bones and is admitted to the emergency room unconscious. The physician has a moral objection to treating patients who abuse drugs. They fulfill their duty to provide emergency care as the only provider in town, and we have a few of those communities, don't we, in our state, and resuscitates the patient, but declines to provide pain medication or any other treatment except what's minimally necessary to keep the patient stable and alive. A practitioner with sincerely held philosophical beliefs that some races are not worth treating and would be allowed under this bill to decline to treat patients of that race. As stated by the attorney from Washington, D.C., the organizations are covered by this, but this bill does not cover the individual. And lastly, a person who objects to the use of blood products could apply for a job, be hired, then refuse to do anything related to blood collection, storage, administration, or record keeping. The healthcare facilities that employ these individuals have an obligation to provide appropriate care regardless of the conscientious objection of each of these individuals. But the bill does not provide recourse to the facilities acting as employers to accommodate these individuals in these scenarios through transfer or reassignment to an equivalent job, since the bill defines transfer or reassignment as prohibited discrimination. The only option available to the facility is to employ additional employees to fulfill their obligations to give appropriate care. Doubling the staff in a rural hospital isn't feasible, sustainable, or doesn't make sense. Conspicuously absent in this bill is the patient. The bill doesn't mention the patient one time. It puts healthcare providers, facilities, and payers ahead of what we all agree should be the focus of healthcare, the patient. Under this bill, a provider doesn't have to notify a patient about a diagnosis or refer the patient to an alternative provider. That is important. This bill is a dangerous expansion of protections that will shield persons acting in bad conscience, result in a myriad of harmful unintended consequences, and is wholly unnecessary. I ask you to please vote no.
Please unlock the voting machine when the members proceed to vote. Please display the vote.
Mr. Speaker, there were ayes 25, nays 41, excused 4.
House Bill 1247 having failed to receive a vote of the majority of the members elect, is hereby declared lost.